Hello, and thank you for joining us for the SLW Institute webinar, In the Age of Amazon, Modern Problems for Brand and Trademark Holders. Please feel free to submit any questions using the Q&A feature on the Zoom menu. A recording of the webinar and the slides will be emailed to all registrants. And with that, I'll hand things over to Mark.
Thank you so much, Michelle, and thank you everyone for joining us here. I hope everybody is safe and well. We're gonna just do some of the preliminaries here while everybody's joining. Looks like we still got a fair number of people adding on here. So again, thank you. Happy to see everyone virtually. Appreciate your attendance and hope everyone is safe during this time. Today we're going to discuss some of the new normals in trademarks and brands with the kind of the upswing of online brand management and the problems kind of associated as we're living through this challenging time, as they like to say in all the commercials. Our panelists are really, really excellent people today. That I think they've got some of the best experiences and practicum in this area. So I hope that you will enjoy much of what they have to say. First, we have Pamela Huff. Pamela, could you introduce yourself?
Yes, thank you, Mark. As Mark said, my name is Pam Huff. I'm a patent attorney, but I've been really focusing on trademarks for probably the last, 25 to 30 years now. And so, I've seen many of the issues that we'll address today come up, and hopefully I can give you all some input and some thoughts on those.
And Jessica?
Thank you, Mark. Like Mark said, my name is Jessica McDonald. I'm one of the more recent additions to SLW, but I have over 12 years experience working with trademarks. And like Pam, I too am a patent attorney. However, my focus really has been on assisting clients with trademark matters.
And yours truly here, as I'm acting as the moderator for this one. I'm the chair of analytics for the firm. And I'm here as well as kind of a presenter to talk about some of the trademark analytics that we have come up with the firm. And I'm a recovering marketing director from a former life at another company. So with that, let's do a couple housekeeping issues. We would like questions as we go through this on Zoom. There's a Q&A tool at the bottom of your Zoom screen. That please type in your questions there. If you want to direct them at any one of us, please put our names in front of that. And then we will do our best to either incorporate them in our discussion or answer them in written form. Or if you have private questions, we're always happy to receive any of your questions that you'd like to address in private through our website. All of our contact details are there. So without a further ado, let's move along here to talk about brand owners and managing online presence. And so Pam, I'd like to have you head this one up, and could you kind of tell us and walk us through how we got to where the brand owners are currently with online brand management?
Oh, sure. I think it's good to have a little bit of background. I mean, I know that we've heard about some of the newer things going on with, selling online and whatnot, but I think it's good to note that this all really started many years ago when you had brand owners increasing the amount of sales that were occurring online. And I think many of us have heard about, IP infringement, counterfeit issues, and that was certainly a frustration with brand owners, and it was. But I think originally it was really more than just that. There was frustration over who could actually sell their products online. You had a lot of products being sold by folks who had no business selling those products. You also had pricing. The original brand owner had lost control over the ability to price their products. So there was just a number of frustrations. I think with Amazon, it's just really a natural thing to talk about in that context, because about 53 cents of every dollar that is spent online is through Amazon. And of course, over the last 2 or 3 months with our current situation with COVID, I mean, I suspect those stats have gone even further and higher. I know there's an Amazon package showing up at my door every day, right? So I think that, brand owners are even more concerned about it, and I think Amazon, of course, is concerned as well. So the original, like I said, the original thing was frustrations from brand owners. Amazon, again, was at the kind of was the target of many of those frustrations with so much of online selling going on through, through Amazon. So they were the recipient of a number of lawsuits that were filed. I think there were brand owners who felt Amazon wasn't doing enough to prevent counterfeits and not doing enough to address IP infringement issues. And then you also had you also had those things going on, but at the same time you had Amazon kind of trying to respond to that. And so one of the first things we actually saw from Amazon, even before the first version of Amazon Brand Registry, was gating. Now, gating still happens even today, but that was one of the original things that Amazon did, which basically allowed certain brands or it prohibited certain brands from selling online without applying and fulfilling certain criteria with Amazon. So some of the things they may have had to do with, say, present legitimate invoices from the manufacturer. They may have to provide permission, written permission from the brand owner to sell on Amazon. So that was some of the original things that we saw. And then that was probably 2016 or so timeframe. Shortly after that is when we then saw the birth of Amazon Brand Registry, the original version.
Okay, well, let's go ahead.
No.
Okay.
Absolutely.
Okay, so let's just jump then, into that the brand registry.
Right. So, this was the first, again, after gating was really one of the first things Amazon did to address the frustrations coming from the brand owners. And I think it did some things. It certainly gave the brand owner control over product listings. There was an increased ability for a brand to control the images and various IP that was on their listings. The biggest drawback that I've heard and in the articles I've read is that the control was really over your own site. There still wasn't an ability to control what others were doing. The brand owners also felt like, well, enforcement was now being kind of shifted to themselves, the brand owner. I will tell you, however, I think I've heard from brand owners that say that was a positive and not just necessarily a drawback. So I think it depends on who you're talking to, whether that's considered a pro or a con. I definitely think that most folks would agree that, the infringement response from Amazon, while it was better, there was still improvements to be made. So there was a number of things that still that needed to be addressed.
What were the basic requirements to get into that original program, Pam?
Yeah, so the original program, so the current program, and Jessica will talk more about this, you have to actually have a trademark registration. The original program you did not. You did have to prove ownership, however, of the brand. And so some of the things that you might be doing is, say, prove that you have the domain that was associated with that particular brand. You had to provide images of the product. You had to provide the packaging that was displaying the brand name. And again, this was all to be enrolled into that first Amazon Brand Registry.
Okay. So let's move on here to a little bit about what's latest and greatest here. So Jessica, you want to take us through that?
Sure. So after the original brand registry program, Amazon moved to what we'll call the brand registry 2.0. And I'll go through sort of the benefits and how that changed from the brand registry, the first version, as well as go through some of the other programs that Amazon's launched more recently, like the IP Accelerator, Transparency, and Project Zero. Just sort of an overview. I mean, I think we could have a whole series of webinars just on each one of these programs and the ins and outs of it. But the brand registry 2.0 is Amazon's more recent version of the brand registry. It was launched in May 2017, so we're about 3 years now. I think the biggest change, it's very similar to the first brand registry, but the biggest change, like Pam said, is the requirement to have a trademark registration versus previously only having to provide the website images, images of the products, the packaging. But it still gives the brand owners increased control and protection of their products. So some of the benefits, you're identifying yourself as a brand owner to Amazon, as well as resellers who have permission from you. you have, I think, even greater increased control over your product listings from the first brand registry. You know, the titles, details, images. It unlocks for you videos, Amazon storefronts, which are sort of mini branded websites within Amazon. Mark, if you could just back up one slide if possible, just.
Sure, apologies.
Yep, no problem, just on that one, and then we can jump on to the next one. And then it also has access to increased search features, which weren't part of the first one. You can search by brand, trademark, product name, and now also product images itself. So it should enable brand owners to more quickly identify what listings might be problematic. And then there's a dedicated tool where you can report a violation within the brand registry. And the goal is really to expedite the removal of these. I mean, you've already gone through the step of proving to Amazon that you are the brand owner for that. So it should get them removed faster because that's one less thing that you need to prove to Amazon. And then there's other features with it, enhanced customer support, and then marketing programs, reward program, review programs. Those kind of things are all unlocked when you register your brand with the brand registry.
That brings me to a question. What are some of the challenges that you've seen getting into this version of brand registry?
Sure. I wouldn't say I've had any really firsthand experience with this, but there's been, I've seen reports and heard frustrations from a number of sellers that have been pulling their products from Amazon sort of more recently. Either it's, you know, failure of Amazon to crack down on infringements. Again, these programs shift the burden really to the brand owners to police their marks. And just the damage that's been happening because of counterfeits on their site. The interesting part, I believe, is that because you're enrolling in this brand registry, it's easier for Amazon to enforce its standards for selling at Amazon. I've heard reports of brands feeling increasingly pressured by Amazon to sell directly to them at wholesale, and that you're not allowed to sell direct to consumers through Amazon. And that way Amazon's really pressuring the pricing on some of these things so that they can remain competitive with their retailers.
Interesting. Well, that would tie into some of the Amazon's shell company trademark filing that we talked about previously, but you know, that sounds very rational on how Amazon might be doing that. So do you have anything else on this slide, or?
No, you can go ahead on to the next. I'll just go through some of these basic requirements for enrolling in the program. So like we've mentioned, you need to have an active registered trademark. So it has to be live, and in the US, it has to be registered on the principal register. And that trademark has to appear on the product packaging. Now it applies to text marks or images that have words, letters, or numbers in it. So if it's just purely a logo without those words, then you cannot register it through the brand registry. You have to provide your registration number, or as we'll get to later, if you have a pending application that was filed through the IP accelerator, the serial number for it, and then some other details about your brand, the product categories you're going to be listed in, the countries where you plan to manufacture it. And then you also need to verify that you are the rights owner of the trademark.
Does that present any other difficulties for our clients?
I'll jump in on that one if I could, Mark.
Sure.
And Jessica and I, you know, you and I have talked about this a number of times. One of the things that I would say is just a pointer, you know, over years, of course, many times you'll move to a different firm, let's say. Maybe you're bringing with you several thousand marks, say, in multiple portfolios. I think there is a drive certainly to jump right away on getting correspondence information updated for the marks that are pending. I would tell you, however, that it's, you know, in this age of Amazon, it's just important to make sure everything is updated on registered marks as well. You know, we've had a number of clients who are going through the verification process and are doing it for marks that maybe we haven't had any, say, recent work for that client, but of course we're still managing their marks. And so the verifications are coming through to the prior firm that I was at. And so, we've gone through, of course, and updated everything now, but that was something that made me at least more aware of the need to make sure that everything is updated very, very quickly if you are making those changes.
And we have a question that jumped in here as well. Does this apply to registered color trademarks as well? Or is it simply the black and white side?
I believe it will apply if it's in color. So if the design, so long as it has words, numbers, or the other standard character marks within it, then I believe it should work for it. I believe the ones on the Amazon website that they give examples of, they actually do show in color.
Okay. And we have another question about why does Amazon not accept marks on the supplemental register? And any suppositions?
Well, I'll jump in on that one too, as well, Mark, and just say that my understanding is that, of course, when you're on the supplemental register, it's essentially an admission that it is not yet acquired secondary meaning, so it's not yet a mark. And so, with the requirement to be on the principal register, is it actually the brand must actually be a trademark and not in the period of acquiring the secondary meaning.
And of course, they don't accept common law marks on the registry that have no other registrations.
Correct. Yeah, you need to provide that federal registration number.
Absolutely.
Yeah, I mean, that issue with the supplemental register, I mean, in my experience, that's sort of the most common issue that I've seen from clients trying to sign their brands up for brand registry and it doesn't go through, that they've come to me and said, well, what's going on? Most of the time it's because it's on a supplemental register and not on the principal.
Yep. Well, let's move on here to the IP Amazon Accelerator, where I was so excited to get to previously. I advanced the slides way ahead of Jessica. So let's go there now. And say one clarification. The question was really about a color mark, meaning like Owens Corning pink, as it is for insulation. So the actual registration of the color is mark rather than and we probably want to expand that to sound marks as well, like Intel Inside.
Yeah, I mean, I don't know for certain, but I would anticipate that since they require either a text-based mark or a design mark with text of some sort in it, that would not be something that you'd be able to register.
So maybe a bridge too far at this point. Okay, let's jump onto the Accelerator with all my stops here.
Yeah, and I think that ties in great with the question with the supplemental register because it's a potential issue with this. So Amazon launched this IP Accelerator that is connecting businesses with a network of IP firms. And Amazon has had some programs in the past, I believe, to connect some of their sellers with other types of services, like if you need photographs of your product and things like that. From what I understand, this is sort of the first entrance into legal services. So they have 11 different firms with pre-negotiated rates that customers can go to file trademark applications. And the benefit to using one of those firms is that you're immediately invited to join the Amazon brand registry once you've filed your trademark application. So you don't have to wait for the registration to actually issue, which can take, average 6 months to a year, even longer, several years. So it's a way for brands to sort of jump in line and get that access immediately to all those features I just discussed with the brand registry. It's relatively new, so it's going to be interesting to see what happens, but there's some drawbacks here. There's potential for conflicts with Amazon if these firms are asked to act adverse to them or grounds to disqualify them. And I think there's a huge potential here for abuse with it, because the reason for having a registration with the brand registry is that you're really making sure that that brand owner has trademark rights to what it's trying to register. When you're opening the door and allowing these pending applications to then have the same rights, it's in essence Amazon creating its own trademark registry, and I think it affects the overall reliability of this vetting process for the Amazon brand registry. there's going to be parties who can manipulate their brand listings just by filing applications. So you may have these generic or descriptive marks, or even marks that conflict with others, but that party is junior to another party that may actually have legitimate trademarks to it, that are being able to enroll their brands in the brand registry. So it's yet to be seen, I think, of what effect this is going to have, if these applications are going to be considered essentially the equivalent to a registration in these takedowns, because it could lead to problems of parties who may actually have superior rights to some of these parties. Their listings may get removed, and they're going to have to go through the process to get them reinstated. So, I'm not sure what's going to happen with that, but it's going to be interesting. I mean, the other issue is, what happens if the trademark application gets denied at the trademark office? Does it still stay registered with the brand registry? I mean, Amazon says on their website that they're regularly monitoring the trademark status, but how often is that? What are they doing? And then what's going to prevent that party from just refiling?
Refiling, that's exactly what I was just going to say, Jessica, is that I think I've heard that question many times. If it doesn't mature to registration, are there any rules about immediately refiling, getting right back in line? Even if you have a mark that is ultimately blocked and is probably not going to register even the second time. So it will be interesting to see how this plays out.
Yeah, and also I think it's, with brands that Amazon itself is filing in procuring of goods to push through its own site. Also, these 11 law firms, you may get to a point where you actually see trademark bullying by someone who's in the accelerator program with other valid applicants out there. So I think there's a lot of potential agendas that haven't come to light at this point.
Yep,
but yeah, so let's move on to transparency.
Yep. Sure. So transparency is one of the more recently adopted programs as well. It's a product serialization service to identify individual units of a product. And the real purpose of this is to prevent counterfeit products from reaching customers, because that is one of the bigger complaints on Amazon and brand owners. So what happens is, once you enroll your product in this transparency, the product information is entered into a database, and the brand owner receives a series of these unique T-shaped, two-dimensional codes. And the codes get applied to each individual unit of the product. What Amazon is then going to do is that they will scan these codes on all products that are being shipped out to customers, either sold by Amazon directly, or if it's being sold by a third-party seller through Amazon, before they get shipped out, to verify the authenticity of them. There's also an app that a customer can download onto their phone, that they can scan that code when they receive the product, make sure it's authentic, and then there's some other associated product information that they could obtain: the date, location, and manufacturer. So it's really the effort to cut back on these counterfeits. It's going to be an increased cost to a number of brand owners, just because you're going to have to manufacture these products and get a way for each individual unit to have this separate code. And what's interesting is that for any SKU that's enrolled in this program, you have to apply these codes to every single product, whether they're sold through Amazon or not, just so you can't cut out resellers of these products. Amazon has very clearly said that there's penalties for other for retailers if they were to eliminate those codes from certain other products, whether it's applied by a sticker or if it's actually printed on the packaging. I mean, it's certainly logistically more difficult for some brands, but it seems like the brands who have enrolled have been happy from what I have seen on it. I don't think it eliminates everything. I mean, even because the packaging is legitimate, are you sure that the product within it is actually legitimate, especially if it's a hair care product, personal care product, something along those lines?
Yeah, that certainly seems to bias against the lower margin products, or the more fungible goods that you would find on Amazon, to have those required on there. So what do we need to do to enroll, Jessica?
So in order to enroll in transparency, so it's available in certain countries that are listed here, one of which is the US, you have to verify you're the brand owner. So you have to be registered in the Amazon brand registry to unlock this ability to sign up for transparency. You have to have a global trade item number, and then again, this ability to apply the codes on each unit that's manufactured. Now there's a cost to enroll in this. You actually have to pay to obtain these codes, and it's based on volume. So it's somewhere in the line of 1 to 5 cents for each code. So for a brand that has a high issue with counterfeit products, you know, it might be a worthwhile investment for them.
Yeah, so a question that did come in that was just asking, is it a different code for each unit, or is it a code that is indicative of the SKU by the manufacturer? You know
so it is a separate code for each of the units.
Oh, boy.
So if you want to, you're manufacturing 5,000 of these products, you will pay for 5,000 separate codes, and then one code will get applied to each product. I mean, there is certainly some concerns that parties are going to figure out a way how to mimic these codes. The fact that it's a serialization, I think, makes it a little bit more difficult, but you know, where there's a will, there's a way.
Indeed, as we've seen in many cases.
Mm-hmm.
All right, well, let's jump. Any best practices, Jessica, or should we move on?
Yeah, I think we can just move on. That was about everything I had for that one. And
Okay.
this should be the last of the newer Amazon projects. So this is Amazon Project Zero, and it's a program for automated self-scanning and self-service removal of counterfeit products. This was launched in February of last year to companies that were invited to participate, and then in October, it was available to everyone. So what's interesting about this program is that the brands do not have to contact Amazon to remove listings that they believe are in violation of their rights. It's a self-service removal for brand owners to go in and remove the listings themselves. And it has machine learning and artificial intelligence, and it takes the data that's being used to strengthen their automated protections for these removal of products. We can go on to the eligibility for that.
Okay.
So here too, you have to be enrolled in the Amazon brand registry, and the enrollee has to be the rights owner, so not a registered agent for the brand owner. And then really the big requirement for this is that you need to have a certain prior acceptance rate of reported infringements. So within the prior 6 months, the party has to have submitted reports of potential infringements with an acceptance rate of at least 90%. So that makes it, you can't join this Project Zero right away. I mean, you need to have 6 months worth of takedowns of other product listings before you can even enroll in it.
I'm assuming that's to demonstrate that you have an enforcement, monitoring scheme.
Right. I mean, because they're allowing the brand owners to go in themselves and do it to avoid the risks of abuse, they need to maintain this high standard. So it's interesting. It says, Amazon says that once you are enrolled in this project, you have to maintain an accuracy of 99% of takedowns of being legitimate to keep the privileges to enroll in this program. So they give you training when you first enroll, and then Amazon says they continually monitor those parties who are involved in this.
So that sounds like a good way to keep the people honest. You won't have the same problems you've had copyright striking on YouTube with. So I think that's actually a very positive way to keep it going.
Yes. Yeah, I mean, that was basically all the programs we had. You know, I'm putting all of this together for the presentation. You know, we really wanted to consider the impact and the importance of Amazon and potentially the correlation to some of these changes that we've been seeing at the USPTO, especially with, like you're just going to discuss, with these fraudulent specimens.
Yeah, and so let's move on to that. Part of what I do for a living is I'm able to use machine learning and AI to and other human review to extract bits and pieces from various areas of the federal registrations. So we have developed a number of ways to go through and work through specifications, specimens, filing entities and such, And so one thing that we've come forward in conclusion when we've done our analytics in the market space is that the retail classes in trademarks are flooded. And in some ways, Amazon is a direct item that people use as evidence for this reason. So we're going to talk about China in the sense that China has become a very heavy trademark filer in the USPTO. I mean, they were 14% of all marks in 2019. I believe that was according to CompuMark. But I just did a recent search here, and currently Chinese owners have filed well over 12,000 ITU marks in 2020, which is 17% of everything that's been filed in the U.S. market in this space. And in many cases, the specimens are really, really awful. And just they're fake, they're substandard, they're cut and pasted from other places, and the use in commerce requirement in many cases is become a Amazon page. And we'll show some of this in a little bit, but a lot of the typical thing is they will have them used in commerce, and they will have an Amazon page that literally it's available right before it goes to opposition. Your page might have been opened up as much as 6 months before, but it goes dark literally the next week after something's published for opposition. And so in response, USPTO has begun tightening some of the requirements. But what is driving this in many cases is various aspects of government subsidies in China, which are paying literally about $800 per U.S. trademark registration, which at least gives a registration profit of about $500 past that filing fee. So there is apparently a cottage industry of people, and it might be law firms themselves in China filing these marks. Now with the switch over to U.S. returning requirement, that has become a little different game, and I think they've tightened up the profit margin, but I think we'll see in many cases this is still happening. So I'm going to go through a number of examples here after this, and then we can talk more about this. So it's not just the U.S. that's happening as well. I think there are a number of places. Taiwan, Macau are given subsidies. Hong Kong administrative districts, and also items going through the Madrid system as well are getting essentially fees to go put this forward into those marketplaces. And so what's happening is that especially large trademark applicants who go through a process of clearance you're running into more and more of these problems. In many cases, you see various and sundry marks that are just mixtures of consonants and vowels, which don't really have a meaning. So they're really trying to shoot for the very highest end of the marks where they're not going to get a rejection for descriptive or non-suggestive uses and genericized uses. So let's move on to the next slide here and just start with an example. So here you have a recent registration. I think it was in the end of April. Daily Food, this is the specimen they submitted. The brand is, as you can see, it's not marketed as a trademark. There's no, TM logo on it. It appears to be a bag of balloons. But then, once we start to apply image searching tools, let's see what the rest of the world looks like. So we found that Daily Food, Daily Fly, they do have an Amazon page, and they actually do sell balloons. But if you switch back and forth, it's kind of hard to say that balloon set is relatively similar to this balloon set, which has a fair amount of highly stylized, dinosaurs and whatnot on its packages. So, this is where the investigation in many cases in trademark specimen would stop, because if that specimen is rejected, they could resubmit this and here's a live Amazon page to show that we're actually using this in commerce. Now, if we take that to the next level, if we use image search technology, we realize that on Amazon, there's about 56 other brands selling exactly the same item with the exact same photo. So you can start to see where this specimen creep starts occurring here. I've analyzed most of the Chinese filings in the retail class over the last year, and the number of trademark specimens where you have a stock photo like this being used as the good to be sold, it's about a good third of those registrations I can find with the simple reverse image search. So the tools we're using here, we do have custom scraping stuff where we've done for big projects, but a lot of this you can download as a browser extension. So I just want to give you a sense that this isn't hard to do. This is not something that takes me more than half a second to find a bad result once I find a specimen that it looks suspect to me. So,
Mark, if I can interrupt real quick on this,
Sure.
I heard a presentation actually early last year in 2019 about some software that the Trademark Office was actually trying, software that would identify when duplicate specimens were being used. Do you know where we are with that? I mean, I haven't heard that it's been approved. I just heard they were in the kind of the testing phase. So, I mean, obviously the PTO is aware that this is going on, but I wasn't sure how successful the software has been or if it's made it past the trial phase.
Well, I mean, my last knowledge on this goes back to December. So, I mean, that was when they were, in the testing phase. And here it is, nearly June. And I haven't heard much since to this. I mean, the technology has been on Google and Bing and, 3/4 of the rest of the search softwares for a good decade. So it's not like they're doing anything unique and interesting. But, it's very much right as the lost art. But somewhere in a building there's a crate with the software in it. And we'll see it when it gets out. But I think what they're trying to do right now is they're trying to do these manual steps, like requiring U.S. Counsel, requiring this, that, and the other thing. And I think some of those fixes are in already from our Chinese applicants on that. But one of the questions here, have we encountered an uptick in Chinese law firms encouraging applications to drum up business? We have not seen any, to my knowledge, but I mean, please answer, Jessica and Pamela, if you've seen any other encouragement from law firms from China encouraging these applications. I have not.
I have not. No, I have not either.
Yeah, me neither.
Yeah. So, but I mean, in the end, the analytics will show that there are any number of U.S. attorneys who have engaged in this, and we have, I'm not going to disclose names here, but we have attorneys that are filing upwards of 20 applications a day from Chinese owner every day of the year, 7 days a week, and so it does, it does appear that the fix is in on much of that. Sad to say. Let's move on here to another example. Here, this is another specimen filed by a U.S. attorney for a Chinese applicant. As you can see, it's something that appears to have one of those label machines pasted on it. The item appears used, and I can't quite tell what it is and what it is. It might be a game controller. It might be an exercise belt. It doesn't really look like anything I'd fish with, but this is submitted by and with also an attorney in tow, a U.S. attorney in tow. So these specimens, to pull them off the web a couple of weeks back, and they're happening as we speak.
Mark, in your research of these types of filings, are you seeing that if an office action is received that they're responding, or are they just letting these applications go?
No, I think the responses are increasing here. So, I mean, I think that because I've also noticed in my own legitimate clients that my responses in my specimens have to be better, because I think that they have been, the Trademark Commissioner has been under the gun for a lot of these specimens here since literally 2017. So I think that some of their response has been that they're really getting pushed from a large number of trademark holders to do something better about this. So they've just, in many cases, it's made it harder for me as a practitioner with a legitimate client.
Oh, sure. I mean, I can tell you I've had rejections because my specimen looks too good. I've had rejections because my specimen doesn't look good enough. So it's, I think we're all going to have to sort of find the happy median there.
Yeah. And, you know, and then we, you know, when we're continually confronted with things like this is, you know, the game of find the brand, because the brand is supposedly, you know, this, you know, mixture, word salad of letters and vowels. And the specimen is literally a box of toys from maybe the same toy set, but no brand apparent in there. Again, also filed by a U.S. attorney in you know, a couple additional classes that which include cosmetics and dress-up accessories and inflatable toys, and also an educational toy, which this might appear to be. So, you know, I think one of the examiner's responses here, when you get a lot of different diverse classifications being filed for, I think that you're going to see a lot of pushback to make sure there's a specimen in each of these classes. The previous one especially, where, you know, a fishing bait compared to a weight, an exercise belt. So let's bring Amazon into the discussion now and use an example of Amazon. So, you know, this is an example of a dead specimen with Amazon. So this was the specimen submitted to Amazon from showing use in commerce as of 2/12/20 to USPTO. This is actually their screenshot from the registration itself. And now you can see the mark is Kutapu itself. And that has moved forward. You know, I think it would publish for opposition in early April. And if we move forward in time to, you know, that current website, it's currently you can still get to it on Amazon if you Google search. You cannot get to it through Amazon. You cannot find Kutapu as a item there, and they've gone currently unavailable. Mark hasn't even issued yet. They go dark on Amazon almost as quickly as they get the item published for opposition. Because I mean, something like a Kutapu, you're not going to have an opposition filed simply because it's you know, one of those highly you know, original names as they're wont to file. So,
and Mark, we just got a question in about you know, wondering, I say question, a statement kind of wondering if some of these that are being filed by, quote, U.S. attorneys, if they're really U.S. attorneys or if they're just someone inserting a name, you know, checking the boxes. And I'll tell you that, you know, that discussion has come up several times. One of the things that I know we've done here at SLW is instituted some checks and balances, right? Because now that we have to provide all of our information in, I say our, being the attorney's information, I know that it's supposed to be masked. I think there was some success with that. I don't know if it's completely been successful. And so one of the questions I had was, you know, would it be, you know, it's not unheard of that some attorney's information has been taken and that the filings are being done with that information. So I think it's certainly possible that, you know, it's not an actual attorney. Maybe it's, you know, information that's been stolen. That's possible.
Yeah, and the USPTO sent out a warning to trademark practitioners to monitor the filings to make sure that there are no applications that are being filed unknowingly on your behalf. I mean, they did institute the fact that we have to provide our state of bar admission, the year of admission in the filings just to ensure some check of legitimacy.
yeah, and I on a regular basis will extract the attorneys that are doing high counts, and you know, I do go in and look at, you know, they are actually real attorneys, you know, in many cases, registered to practice in states like New York, you know, but they're all over the place. They're, you know, but they're typical. They have one attorney. Sometimes that attorney is, you know, given an email. You know, a lot of times they'll have a Gmail address instead of a firm address, or else you'll find that attorney is actually working for a different law firm than specified under. So yes, I think there's an active opportunity for fraud in this respect. I certainly, as a practice guideline, would really push people to, if you're a practitioner, see if anybody's borrowed your name or likeness in the attorney registration, because it appears that the use of Gmail still is allowed versus another, having an attorney law firm based email required in respect. The law firm has to agree with the email address and such. It just hasn't been enforced, at least at this point.
Yeah, it'll be interesting to see if the USPTO starts cracking down on some of these practitioners. I know Pam and I have sort of talked of why are these attorneys doing this? Why are they putting their licenses in jeopardy with this? Because now they have the information, they can certainly report it to the state bars that they're associated with. So we'll see if some of these multiple filers, if it leads to problems for them.
Yeah, and there's a number of them been doing this, since 2017. I mean, when you look at somebody having over 2,000 filings since January 1st of the year, and then you can find their name on a decent sized firm website, you're kind of wondering why are they taking this risk? It just doesn't make sense. Thus being said, so let's put along here. So I mean, just how do we address this? I mean, a lot of what we're doing is we are identifying items that are mocked up, digitally altered. We're looking to find better ways to discover these specimens, these poor specimens, and it certainly has led the USPTO to put more attention to this and identify and refuse specimens. We've got some statistics put up by the USPTO later on here, but it isn't all. It isn't something that seems to be high focus, and I got a couple examples that show that. So these are earlier last year, so hopefully they fixed these since that time. But here's an example of 3 different marks on the same clothing item, filed literally on the same day. They were all put in front of the same examiner. They were all published for opposition without problem on the same day. So the problem is the USPTO. I think they've got a lot of throughput problems where everybody is overworked. But when something's been in front of the examiner on the same day, I would encourage the thought that maybe something better is needed, for an image search tool within the practice groups.
We just had another question come in about, pointing out that patent filings have several levels of scrutiny, for an account to log in, and wondering if electronic trademark filing system has that. And so the answer to that is yes. That is one of the things that changed recently with the different requirements now. And one of them is to actually have to log into a USPTO account in order to file.
Absolutely.
Yeah,
go ahead.
I was going to say, I had read something that they were working on potentially future phases of it. So the first phase was this requirement to log into the USPTO.gov account. But the next step would be some sort of security process to verify the account holder's information. So possibly something more like the EFS system for patent filings. They don't currently have that. It's a little bit different. So they've been talking about it. We'll see when it happens.
Yeah, and I think that would also help flag high frequency filers, that should maybe be deserving of additional scrutiny as well. So, and just another one here. I would want to move on to our next section, but things like this where these are specimens again published the same day under the same examination individual, where things like this just should not be allowed without a rejection. To be applied to that. Anyway, let's step into the USPTO practices. Jessica, can you take us through that as we're going?
Sure, I'm happy to. We've sort of touched on, the highlights on this, but I'm happy to go through them a little bit more specifically. So like we mentioned, this requirement for U.S. licensed attorneys is implemented last August, and it applies to any applicants, registrants, or even parties to a TTAB proceeding that have a domicile outside the U.S. And it requires they be represented by a U.S. licensed attorney. And like I said, when you file stuff now, you have to provide your registration number and bar admission, year of admission. So it's the hope that these filings are more legitimate and really comply with the U.S. laws.
It's been interesting over the last few months. I've definitely seen a huge increase in foreign associates, foreign counsel reaching out who have actually filed, who were unaware of the change and have filed applications only to receive an office action, right, to secure U.S. counsel. So I've definitely had seen an increase and had a number of conversations with foreign associates about this. And of course, they're not very happy about it. But I mean, I think at the same time, they also understand why the PTO has implemented it.
Yeah, and I mean, and the next slide just is sort of a quick overview provided by the USPTO of some of these statistics in it. So the U.S. counsel requirement went into effect in August of 2019. So if you look at the USPTO divided out the data by Chinese applicants and non-Chinese applicants, I mean, you see there's a huge spike in filings in July of 2019, right before this rule went into effect. You know, if you look at the non-Chinese foreign applicants, it's remained about steady throughout the before and after this rule went into effect.
Yeah, and I'll put some color into this as well, because I mean, I do my own analytics along this line, and I think that the counts, if you recall, I mentioned that there are somewhere around 16,000 filings in 1A here since January into May. I'm not sure what they're counting in this statistic, but my counts appear to be a little bit higher than this, just in 1A basis filings. So yeah, but I will say that the general trend is there was a spike, and then they have recovered to a certain low roar as they're going through this. So Jessica, do you want to jump here?
Sure. So like we discussed before, the USPTO has increased examiner training back in June 2019, and then they issued an examination guide in July 2019 regarding specimens and just the increased scrutiny. They set forth in the guide several factors for the examiners to consider when looking at these specimens. One of the big ones that we've seen is if you use a website, screenshot, you have to make sure the URL as well as the date of access is on there.
Yeah. I was going to jump in real quick on that, Jessica, and just mention that, I know that it becomes a little more, it seems like it wouldn't be difficult to provide the URL, with the date of access and whatnot as a specimen. I think that, what we've been doing is kind of a combination of Adobe with Snagit. It's not always the easiest thing to do. So the jury's still out on this other software, but we are looking at software. One is called Fireshot and one's called Awesome Screenshot, just to see if those make it any easier to submit a screenshot as a specimen.
And just to jump in there, the screenshot, you could, the tools that we mentioned here capture the entire web page, so you don't have to scroll through that thing. So you end up with a very long photo that you're submitting, but you capture the entire screen. Also, Amazon has taken an additional step to actually show when a web page has gone live. So, I've seen the websites go live, a lot earlier. The individual pages have gone live a lot earlier, in the hopes that they get a sale on something they can actually prove actual use. But then they go dark very, very soon afterwards. So,
yeah, it's interesting.
So let's continue here. We have a few minutes left here, and I want to make sure we get through our deck. Jessica?
Yeah, I mean, just a quick point on this. I mean, you could see there was a huge spike in October of 2019, which actually coincides with, it's about 3 months after the attorney rule went into play. So that's about the average time from filing until examination. So you could see all those 20,000 that were filed in July of 2019. I mean, there was this huge spike in refusals for fake or altered specimens.
And then just to add to that, I mean, I did notice that there are a number of, because of the profit margin is only so much in these things, that a number of the Chinese applicants do abandon their filings at that point.
Yeah, we can jump on to the next program as well. This is the post-registration proof of use audit program. And this is trying to crack down on, once the mark's registered, when you file your declaration of use, the USPTO in certain situations, if your registration meets these requirements, they potentially may issue this audit. And you can see here, it depends on how many classes you have and the number of goods or services in each class. And then you can jump to the next here. So if you're audited, what happens is they'll issue an office action identifying 2 additional goods or services for each class that's being audited. And you're required to respond to it and provide proof of use for each of those goods and services identified. If you send it in, it's acceptable, the USPTO will send a notice of acceptance. If it's either you don't provide acceptable proof of use, or, which is interesting, if you delete goods or services in response, the USPTO issues a second office action that requires that you provide use for all of the remaining goods and services in the registration, which could be a huge burden if you have a very lengthy list of goods and services in your registration.
One of the other things I had heard was coming as well, and I don't know the timing on this, but I was discussing with Foreign Counsel just the other day. They had us filing in the U.S. An application like you've mentioned, Jessica, with an incredibly lengthy description of goods and services. And they understood the audit program, but if we were audited, it was going to be likely that there would be one of the goods that would need to be deleted when we responded, which again would trigger this proof for all of the remaining goods. One of the things that I had heard, again, and don't know the timing, but I have heard that the PTO is going to begin charging for, if you want to keep the application, charging for all of the goods and services that are then deleted. So an additional fee, which would obviously be incredibly burdensome for these lengthy applications.
Right, because it's on a per good or service deleted, which is
correct.
Could be problematic. So, I mean, I think it just shows the importance as practitioners of carefully reviewing with the registrants when filing these to really make sure they do have use with each item.
Yeah, and other things that have been suggested is, actually requiring, some of the text marks to be put in to actually be something that is, not just a word salad or a jumble of words and letters together with, that don't follow any, speech rules and that sort of stuff. Because, in so many of these things that they're really trying to, just have something sail through without a fanciful declaration, just to make the money as quickly as they can. So there have been a number of discussions around that, as well as maybe adding word salad prohibitions. So more to think about here. So Jessica.
Yeah, so just to sort of quick on this one, I mean, these are some of the USPTO statistics on the program. They've issued about 9,000 of these post-registration audits so far. It's been interesting. They didn't receive a response for about 30% of them. They did receive responses then for the other 70%, but of those, about 35% of them deleted goods or services. So you're looking at about 2/3 of these responses either are 2/3 of these post-registration audits being issued either no response, or if they did respond, they were deleting goods. So I think it really shows that this is a huge problem.
Yeah. Just closing up here.
Yeah, this is really just a summary of some of these updated filing requirements. Like we had said, the login through the USPTO, and they're working on those future phases, mandatory electronic filings. And then more recently in February, they're requiring that applicants maintain a valid email address on file with the USPTO. And I'd heard, due to concerns, they're still working on masking that in all viewable documents through the USPTO to avoid situations where people are reaching out to the owners of these trademarks and applications, directly with solicitations and such.
Absolutely. Well, with that, we would like to say very, very much thank you. Please, any other questions here? We happy to answer any other questions you're going. Please think about reaching out to Pamela and Jessica if you have any other questions. Reach out to me. I'm always happy to take questions of talking about trademark analytics. But with that, we'll let ourselves coast down to the end of the presentation here, and we see a lot of thank yous on the questions here, but also happy to answer things privately. So with that, everyone, thank you so much for your time. Thank you so much for your attention. Any other questions or new suggestions for other trademark and such presentations? We would love to hear your thoughts. So thank you so much, and have a great day. Bye-bye.
Bye-bye.
Bye.